for her release. We thank you, unless there's a question.
So on the flip side,
yes,
Mr. Witty, if it's about speculating, even if to say what they are alluding to is right, because the DPP has a right to amend.
Yes, that's correct. And that's what 135 says, now that you brought it, Your Honor. That if the court finds that we have not met the test in 134, then you go to 135.
I wanted to say that because I want to give them an opportunity to address that issue.
Yes. That's
so
right.
Thank you.
I'm also blind.
Any other on your end? You are done.
My people say that I carry the donkey. I hope I've done them.
I will quickly respond to the issues raised by management, then I invite the chairman to address it quickly. There is no misconception that, but I want to begin that nilimwacha aongee in token. Your Honor, you have been told that section 94 subsection 1 is what council is defining as normative. In constitutional law, that provision does not qualify to be defined by that doctrine. The simple reading of the word normative means it relates to a norm, a rule, or a thing that should be. So if you are to argue therefore that section 94 subsection 1 is to be constituted or to be construed as a normative derivative vis-a-vis the provision of Article 33, the question therefore posed to the court therefore in determining the norm in section 93 would be, in normal circumstances, how would court regard such a statement of action by the charge sheet? What norm is arising or accruing from the particulars of that charge? And must that norm conform to the provision of section 7 of the 6th schedule? Again, simple reading of derivative means which can refer to something that is derived or taken from something else.
Do you want it made more punchy for a general?
It's about, let's take it to say, section 94 subsection 1. If you were to juxtapose it to the normative derivative doctrine, vis-a-vis the provision of Article 24, cannot then be said to have accrued or arisen from the provision of Article 33. And that is why counsel misses the point. Of course, deliberately so, because he does not want to appreciate the fact that Section 7 of the 6th schedule was enacted so that it can assist the court where an amendment has not been initiated by the relevant authority. I concede it's only Parliament that can legislate. Yes, that I concede. But in the absence of a legislation, what is the import of Section 7 of the 6th schedule if the scope is not such, the scope of application is not such as this one? The reason why the reason why the people of Kenya enacted Section 7 of the 6th schedule, they were alive to the fact that not all laws that may suffer amendments or repeals upon the enactment of the new constitution. And therefore they created an avenue for a magistrate or a judge to have the flexibility of dealing with a situation as and when it arises. It calls you, it limits you and makes you rigid to the interpretation. That is not the expectation. If even when a repeal has not approved of a section that is not in conformity with the Constitution, the obligation of the court, faced with such a challenge, is to make sure that that section does not defeat the purpose for which the Constitution was enacted. And then where do you get that purpose? You get that purpose under Article 10. For the benefit of my learned friend, who seldom practices criminal constitutional law, Article 10 says, the national values and principles of governance in this article binds all state organs, state officers, public officers, and all persons whenever any of them applies to the Constitution. That is not what you're inviting me to. Enact, applies or this law, section 19, section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation.
Council should just stick to what came out and the law, so that we are not
He addressed you on the applicability of Article 10, Your Honor, and I have simply dealing with the question of Article 10. I invite you to apply the tool of the Golden Rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is the Parliament of the United Kingdom. Granted that this country was a protectorate as at then, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya.
Your Honor, seriously.
Yeah, that's what.
Okay, I'll abandon that, but I know the court has noted. Now that we have the new constitution, you must apply the tool that enhances the enjoyment of a right other than to limit it. There is no possibility that the Constitution can give you under Article 10, which provides again about these values, and I want to just mention the value of human rights. That when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights exclusively? If you're then being invited that the only jurisdiction is under Section 8, threat, violation, accepting that Section 8, again you must interpret it, accepting that Section 8, again you must interpret it in a manner that advances the enjoyment of that right other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, Clause 2, Paragraph B. And this, I'll leave it at this and then invite Mr. Kiraku. Because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their arguments. What we understand, let me finish, sir. Let us just have courtesy. What we understand as response, just sit and finish it.
Council, just sit down.
Yeah.
You know that they don't have a place to sit.
No, you we are pleading with them. We are pleading that in response, so that we don't regurgitate, we just
Alright.
issues that have arisen.
Okay,
Legal issues.
I'll abandon that argument and take that protection. So that, Your Honor, I'll then invite my lawyer friend to proceed. And
So, Mr. Jayne, before you invite,
yes, sir.
don't you think if you urge me, as you have done, in view of that section 7 of the 6th section,
Yes.
do you think I'll be cited for judicial overreach?
No.
It will be a classic case of judicial overreach.
There is no judicial overreach because if I was to read, and again for the benefit of my learned friend who seldom refers to it,
Sorry, this second time I'm not taking it. I am a master's holder in constitutional law. It's not. I am an advanced master's holder in constitutional law. It's not. So you should not throw those shades. I am extremely intelligent and brilliant and learned. You should not throw the shades.
it's one thing to hold a master.
Respect me, because I am not. No. Yes, this is the second time counsel is attacking me that I seldom practice. I am asking him to respect me because he's my friend.
Okay.
That's not the matter.
Yes, Your Honor.
Mr. Which has demonstrated his stellar credentials.
Yes.
Let's not challenge it.
And we are not surprised by those credentials, but surprised by the inability to apply the same.
I am not the kind of person to be intimidated by people like this and that. So this court should just direct him that he respects the court if he doesn't want to respect me, and if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from us.
Actually, about to praise the council for their
Was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent in force immediately before the effective date, continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer. So there will be no judicial overreach, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most obliged.
Thank you, council. You're the last one, Mr. President.
I think the chairman has 2 sentences, just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Whitty has a habit of always rising when I rise. He can stand, I can submit when he's standing. I don't have a problem. But let me make the submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention, if you allow me to read a paragraph, so that as he responds, they also tackle.
No, we are beyond that.
I am allowed to make an application to